Let's take a look now at what effect all of this case law has on lawyers when they draft a commercial contract. First of all, we have to remember that there's an automatic presumption in the common law that a party in breach won't be held liable for consequential loss. But despite the existence of this automatic protection, most lawyers want to state clearly and in writing that their client won't be liable for consequential loss in the event of a breach. And the place where they make this statement is in an exclusion clause. Any written commercial contract will usually contain an exclusion clause in which a party will try to limit its liability for all kinds of things that may go wrong. Let's take the example of the owner of a piece of valuable equipment, such as part of an oil rig, hiring that equipment to an oil drilling company. The exclusion clause in the contract of hire will include a sentence such as, "The hirer is not liable for any consequential loss caused by any breach of contract, including any loss of profits." The difficulty, though, as we know from the Parsons case concerning the loss of farm animals, is that the courts don't always see a loss of profits as a consequential loss. In that case, the court decided that the lost profits were a perfectly foreseeable direct loss, caused as a result of the breach. When a court rules in this way, the party in breach has to pay the injured party, because the exclusion clause doesn't exclude liability for direct loss. So, I guess the million-dollar question is, can a lawyer use an exclusion clause in a contract to exclude liability for direct loss?
Actually, the law on this subject is pretty clear. In a case from 2014 brought by a company called Polypearl, the court declared that if you intend to exclude all liability for direct loss, then there's a danger that the document you're signing can't be seen as a contract. What it is a non-binding statement of intent. This seems logical. What's the point of a contract if you can breach it in a way that causes direct loss and there are no consequences? So basically, if you breach a contract and try to exclude all the liability for direct loss, you probably haven't entered into a binding legal agreement with the other party. What lawyers do instead, and the courts have accepted it, is to strictly limit their client's liability for direct loss rather than exclude it. There are a couple of ways to do this. The first is to set a limit for any claim for direct loss, say $2 million. If the other party accepts that, there's a good chance a court will accept it too. That way, to go back to our previous example, if the hirer of our oil rig equipment breaches the contract, say by returning it a few days late, and the owner suffers a direct loss, both parties know in advance that any claim from the owner is limited to that $2 million. The second way of limiting liability for breach is for a party to limit its liability to not more than the value of the contract. So, if the hirer of the equipment in our example is paying $10 million, over a period of 2 years, for example, then the hirer's liability for direct loss can't exceed that $10 million. This all makes perfect business sense, because a contract is all about limiting risk and setting out in writing precisely how much risk each party is prepared to accept. Limiting liability for direct loss and excluding all liability for consequential loss is an essential part of agreeing how that risk will be apportioned.